Hello, everyone, and welcome to our Driftless to the Delta, Rethinking Water Protections in the Mississippi River Watershed session today. So thank you so much for being here. It's amazing to see all these people in the room. Was anybody last night at Big Grove Brewery for the sister event? There were. Yay. I think we ended up having over 200 people. We had to open up the doors for more people. So it was great to see so much interest and passion around water quality. So that was great. So we're pleased to host our panel of experts, whom I will introduce in just a moment. But first, I'll introduce our Healy Program Director, Blake Roop. So Blake is the one who plans, promotes, and implements programs like today's event. And she and I have been working closely to help chart the course for the next months and years for the growth of Healy since I started about 4 weeks ago. A big thank you to Professor Shannon Reisler, who's done a fantastic job of welcoming me and guiding me through the organization. And today I'm thrilled to welcome two people who, due to their generosity, passion for protecting the environment, and commitment to providing opportunities for law students, have made the Hubbell Environmental Law Initiative possible. So please join me in welcoming Fred and Charlotte Hubbell. And now I'm excited to launch today's panel discussion by introducing our experts. So Chris Dalbum is a leader in Louisiana water law and coastal adaptation. Chris is director of the Tulane Institute on Water Resources Law and Policy, a public service shop affiliated with Tulane Law School. After graduating from Tulane Law School in 2012, he worked for 1 year as a postgraduate fellow at the Tulane Institute on Water Resources Law and Policy, before becoming the Institute's program manager and then assistant director. Chris has done extensive work on legal and policy issues relating to interstate water compacts, comparative water law, Mississippi River management, the Restore Act, and other revenue streams associated with the Deepwater Horizon disaster and coastal and water management. Haley Gentry is the Assistant Director of the Tulane Institute on Water Resources Law and Policy. She joined the Institute first as a Senior Research Fellow in 2022 after graduating from Tulane Law with her certificate in environmental law. She works with public officials, nonprofits, researchers, and other stakeholders to improve oversight and public decision-making related to a wide range of water resource and coastal issues. Her research and publications focus on wetlands protections, insurance and climate change, state-level water management in the Mississippi River Corridor, and Louisiana water policy. Dr. Larry Weber serves as the director of IIHR, Hydroscience and Engineering, a century-old fluids-focused University of Iowa Research Center. In 2009, he co-founded the Iowa Flood Center and currently serves as its interim director and also co-founded the Iowa Nutrient Research Center in 2014. For more than a decade, Larry has led the Iowa Watershed Approach, a statewide research project to enhance Iowa's flood resilience and water quality. And Cody Weisbrod. Cody's a state policy research associate with the Nature Conservancy's Water Policy Accelerator, where he works to research and help states pass effective policies that improve water quality, which includes leading the organization's policy response to the Sackett decision. Prior to his current role with the Accelerator, he worked in government relations in TNC's Ohio chapter, championed water policy initiatives like the H2 Ohio Fund. Before his time at TNC, Cody spent several years as a research and drafting attorney for the Ohio Legislative Service Commission. He holds a JD and Master's in Public Policy from The Ohio State University and a BA in History and Urban Planning from Miami University. Each of these panelists are going to speak for a few minutes on the issues that we all came to hear about today, and then we'll have time for question and answers from the audience as well. So thank you, and thanks to all of our panelists, and I'll let you kick it off.
Good afternoon, everyone, and thank you again for coming out and to our hosts at University of Iowa for all of their gracious events and all the stuff we've gotten to do the last couple of days. It's been great to be here. I've always wanted to come to Iowa because I love Mississippi River issues, and I've been trying to work my way into each main stem state. So if anyone from Arkansas or Wisconsin wants to have me, those are the last two I've got to knock out before Chris and I are going to talk a little bit today about the background of just kind of what's going on with the retreat of federal environmental law. Obviously, Sackett versus Environmental Protection Agency is that key case that has changed the landscape of water and wetland protection in the country. But there's a lot more going on that's not just related to wetlands. So we're going to kind of take a broad lens and focus in. So I'll let Chris go ahead and get started a little bit. Again, we are based in New Orleans at Tulane University Law School, and we work on a lot of similar issues that people in Iowa, but we have some unique challenges being at the bottom of the watershed that drains so much of the continental United States. So take it away.
I'm watching what's happening on the screen.
I'm trying to get rid of this annoying little.
All right.
I thought my slides were bad.
No, yeah.
No, that's right. I'm vetoing your side. Now I'm trying to go back.
No, I think it's fine. This is the one who's going to
Oh,
advance me too anyways, right? Yeah, as Haley mentioned, we're here in large part talking about Sackett versus EPA and the ramifications of that case on application of the Clean Water Act and the definition of the waters of the United States. But it's mentioned, it's only one of several cases that are really driving a federal retreat of as far as environmental law goes. And West Virginia versus EPA was a restriction and across the board, really, and someone overturning maybe some of our landmark environmental law cases like Massachusetts versus EPA, which directed the federal government to manage for climate change. And cases such as West Virginia versus EPA is part of that backtracking from that progress that had been made.
Yeah, it's a unique. I know that West Virginia versus EPA really stood out because it was the first time the Supreme Court invoked the idea of a major questions doctrine. We've seen it in lower courts.
Yeah.
This idea that certain environmental it's not just environmental, but it's usually more broadly applied in the environmental public health context.
Yeah.
But
Even then, I mean, if you were in law school or you went to law school, I'm sure you hear about the major questions doctrine all the time because it's not something that they just made up for that case. Exactly. Raimondo, which was the case that overturned Chevron deference. Oddly enough, this was of all of these, this was the case that like my non-attorney friends like sent me panic texts about, and having been through read enough cases where the court agreed with the Corps of Engineers, but because they were giving them Chevron deference in a decision that I didn't think was a very good one. I honestly was really surprised with the case that really kind of caught the public's attention, but it did repeal the Chevron deference, which was a case from back in the 80s that was intended to give federal agencies more deference, and in a specific case, in order to benefit Chevron and a suit that it was facing from the Natural Resource Defense Council. But we still, going forward, there are still forms of agency deference that exist, and so it's not exactly as if it changes things that much, but we're not seeing it anyways yet in the jurisprudence. We'll see, the resurrection of Skidmore deference instead of Chevron deference, but it's less impactful in the moment than maybe some of these other cases. Additionally, we all know where federal agencies are in 2025. They are cut and are bleeding and are unable to do whatever jobs they used to do, even after some of these recent Supreme Court decisions. It has included things like the Lower Mississippi River Comprehensive Management Study. It was a Corps of Engineers study that was being done between Vicksburg office and New Orleans office, but it was to look at congressionally mandated study to comprehensively study water supply needs for the Lower Mississippi River from like Cape Girardeau, Missouri, And then the funding for that got pulled, right, like many other federal projects. And so these sorts of programs where the federal government was involved in management of the Mississippi River and the waters and the corridor as a whole is really, at this moment, virtually non-existent. Click for you.
Back. Okay, now trust.
Get a good look. It's a great slide.
People like to stop that.
There we go. It's gonna Sackett me.
Yeah.
Okay, so Sackett versus EPA was the most recent Supreme Court case that was arguing over the extent of the definition of waters in the United States. I'm like this close to switching into law, professor, but essentially Sackett restricted the wetlands to which the Clean Water Act protected or applied. And the majority opinion in it involves some pretty intellectually disingenuous strawman and red herrings. However, what they came up with was essentially you need a wetland that has a surface connection with a water body. You need inseparably bound up with them. You need them to be both adjacent and abutting. And essentially with the idea of drastically reducing the applicability of the waters of the United States. I think part of if you want to be generous, right, you can kind of say like, one thing lawyers and judges just are really bad at understanding is what a wetland is. In that, like, sometimes it's wet and sometimes it's land. And so honestly, like, that's hard for people to wrap their heads around. The difference between, like, I don't see water there, how can it be a wetland? And it's like, because it's a sometimes thing, guys. Swamps that you see in Kermit the Frog movies are sometimes dry. So anyways, I think that's part of the problem. But this is also a case where the Corps of Engineers had denied a dredge and fill permit. At some point in the 20 years of litigation, actually withdrew that denial. It is not a wetland. It does not fall under the Clean Water Act jurisdiction. The court took it anyway, even though it was essentially moot as far as the point of the whole case and the controversy in the beginning. So you could probably say that the 9-0 decision, the court said, no, it's not covered by the Clean Water Act, which is what the Corps of Engineers had already said years earlier. All of it's dicta beyond that. However, I don't think it would be too happy because they took the case in order to make this point, in order to sever these wetlands from the Clean Water Act.
And that's the problem, not having a lot of this understood and thought out, because as was noted in one of the concurring opinions, there were several filed kind of showing that there was a disagreement on the actual holding of where the court drew that line, drew that bright line, which we'll talk about in a second, isn't really a bright line after all, because we still don't know the scope of the Clean Water Act. But this is my favorite slide to show people, because when this was coming out, that was our big concern, is that you can't really comprehensively manage water in the Mississippi River and its surrounding floodplain without having some of that jurisdictional oversight over wetlands. And that's what Justice Kavanaugh also said, hey, we might want to think about how this is played into a much broader system of water management and public works authorization related programs. Thinking about flood insurance and what it means to have wetland regulations and wetland mitigation to offset impacts from development in the floodplain. So it leaves a lot of questions. And when all this happened, the Army Corps and EPA had just issued a rule leading up to the Sackett decision, which came out in May of 2023. So January 2023, they issued a new rule after decades of going back and forth between expanding the Clean Water Act and then restricting the WOTUS definition. And Sackett, this 2023 rule went into effect, and then a coalition of states sued to enjoin the rule. So there's several states that do not apply the 2023 rule. And there's handful of states, the other half do apply the 2023 rule. There's been some more controversy because after Sackett came out, it said that significant nexus as a standard to analyze whether a wetland is connected enough to the river or the interstate lake that's in question, that was no longer valid, and that's what a lot of this 2023 rule was originally based on. And so they issued an amended rule without notice and comment, saying they were just complying with the Clean Water Act, but then that got additional litigation because people said that some people said it was a major question, which I'm not sure about that one, but it was also, again, that there's no good, they said there wasn't good cause not to have notice and comment to change the rule. So we're still not left with a bright line test because it is actually kind of difficult to determine the extent of wetlands and wetland regulations and what is a wetland, as Chris was saying. And so now we are still in this patchwork regime of Waters of the United States rules that are split between states. And going into, I think this was in March, the EPA administrator announced that they were going to be doing another new Waters of the United States rule, and this quote here, that follows the law, reduces red tape, because overall permitting costs and lowers the cost of doing business in communities across the country while protecting the nation's navigable waters from pollution. That can be left to interpretation. And then, so that's going on. The EPA and Army Corps have hosted listening sessions, and I'm not sure what the kind of plan is there because it's already been restricted pretty dramatically with this recent Sackett decision. And so it's unclear how much further this new proposed rule would go and whether it will even be an impact that long because there will probably be more ensuing litigation for it. But then there's more recent development in Congress, is this Promoting Efficient Review for Modern Infrastructure Today Act, which I don't think is moved out of committee in a bit, so I'm not sure if this is going to go anywhere, but it would seek to let the EPA and Army Corps exclude individual wetlands and waters from protection, so it could be a much broader, reducing the scope of the Clean Water Act. And then it also would reduce oversight over pesticide discharges and also discharges from concentrated animal feeding operations. So there are like the stormwater management plan. So there could be further pollution concerns if this is passed. But again, things get proposed in Congress a lot and don't move anywhere. So it's just something we'll have to keep an eye on. But Sackett's a really good example of the kind of world we're living in where a lot of longstanding federal regulatory regimes that we've relied on for a variety of things and that a lot of our current policies and programs are based on are suddenly being kind of ripped out from under. And so it raises a lot of questions because most states do not have any comprehensive wetland regulations beyond what the Clean Water Act requires. And Buddy's gonna be talking more about that, so I won't steal his thunder. But it's not just wetlands that are a big concern. Already before any of this happened, the whole idea between the federal and state balance of power is that states have the traditional authority over land and water use. And so water supply and allocation is not something that the federal government can really dictate within states. They can influence it through water quality management and funding to kind of do certain work around water management, but that's a state responsibility. And each state does it dramatically differently. Many states don't really regulate wetlands or water use at all. A lot of states don't have additional water quality protections. And when you're in a shared watershed, I just have the 10 main stem kind of highlighted here, but it's difficult to actually manage a shared resource when you have a patchwork approach and that many states aren't actually regulating this or looking at groundwater. And so it's only kind of creating additional challenges, and we're gonna have to start thinking about different tools and what the states can do to align their water management policies. But first, that requires all of the states in this Mississippi River main stem to actually start monitoring water use and actually making a water budget and doing a lot of different work that sets the background to actually manage this resource. And we're really far away from that. And so it's really time to start buckling down at the state level to get some of this work. And we'll talk a little bit about what's going on in Louisiana. Louisiana is one of the states that took action after Sackett and wanted to change the definition of wetlands to align with the federal reduction. But it's very unclear how this law applies, and it shows the confusion of what wetland regulation and what Sackett does apply to, because we changed the law of fastlands, which is not part of the Clean Water Act. It's part of our state's coastal program, but they're saying it has to be tied to the Clean Water Act. So there's a lot of confusion about that, and that bill went through without really any discussion. And so it's not really clear if we're going to be regulating less of our coastal wetlands now, but that's a different regime. And then we also, at least in the bright side, we finally got authorization in our Natural Resources Agency to create a statewide water resources plan. We don't have one. We actually don't regulate water use at all in Louisiana. And so this could be a first step into getting towards more an understanding of who's using surface water and groundwater and where there are other related issues in the state. But legislator didn't give a lot of tools for the state agencies to start regulating and monitoring water use. So some to be desired, but it's at least a step in the right direction. But hopefully.
So maybe it's time for them to institute a comprehensive water code for the state of Louisiana.
Yeah,
it's an idea, just hadn't came up on the top. It's been 11 years that we've been working on this. Yeah, all the way back in the Stone Age of 2014, the Louisiana Senate passed a resolution asking for the Louisiana State Institute to form a committee to draft a comprehensive water code for the state. And the Louisiana State Law Institute said, sure, we'll form a committee. Is there any money for it? Of course not. And so it became our job, basically in our shop, and because we're suckers. And we've organized the state. We've done a lot of comprehensive water law studies across the United States and actually into Latin America and Europe and places that share our sort of civil law property kind of history that we have in Louisiana. And so what we have done is put together this code. It is essentially drafted at this point, and so we are hopeful that it will be approved by the Louisiana State Law Institute, who I should admit did supply donuts. Once it gets approved by them, then we'll have to send it to, it'll go to the legislature for the spring session. At which point, everybody and their lobbyists will try to put exemptions into it. And so that'll be the real test of it, is sort of whether or not it can make it through that process and still be whole, and still be the sort of thing where, like when we say that we want government to function like a business, no business, doesn't know what they're doing with their products, doesn't just kind of, that's 40% of their inventory out of what they count. And these sorts of things is what we need to really hope that we're going to be able to get through our process in Louisiana.
We're running out of our time, but I wanted to just put these 3 recent stories up to kind of show like we're dealing with in Louisiana with new development, with new industries coming in, and there's lots of implications for groundwater and surface water management. And also at the bottom of the Mississippi River, we've had to build a sill 4 years in a row to stop the Gulf of Mexico from intruding into New Orleans water supply, and it's been compromising communities south of New Orleans. And yeah, so.
But we needed that so that we could get Panamax ships up the river, even though those ships couldn't get through the canal because there was a drought there.
Yeah.
All right, we'll talk some more later. Thanks, guys.
Okay, well, thanks, Chris. Thanks, Haley, for talking about setting up my presentation well, for talking about the federal stuff, because I don't like to do that. It says state policy in my job title for a reason. So what I'm going to talk about is just what comes after Sackett for the states. So the Sackett decision is issued, but what does that mean at the state level? And what are we kind of seeing across the country? And also, what are the challenges and opportunities of working with states after the Sackett decision, especially around wetland protection? So the picture here, this is Sackett versus Environmental Protection Agency. We just talked about that. The picture here is the wetland that's actually in issue in the case. So that red square is the Sackett parcel that, was regulated and then they decided never mind. But the point of Sackett for my presentation is that under the Clean Water Act, you have to kind of make this complicated connection to traditionally navigable waters to get that federal hook. So you have to be able to draw this connection, which is what's at issue in Sackett, is saying, okay, well, there's not enough of a connection for the Sackett's wetland, which 9 of the justices agreed, but then 5 of the justices are saying, okay, you have to have this relatively permanent water, and then the wetland has to have a continuous surface connection to that water to make this connection. So this makes this difficult and open to challenge because you have to kind of make this long looping connection for wetlands to be regulated under the Clean Water Act. And the reason is because a lot of our federal environmental regulation has to come under the Commerce Clause. The federal government doesn't have just expansive, unlimited authority to regulate land and water, especially. But I'm already done talking about federal things because now we're going to talk about what Sackett says about states. The majority opinion says regulation of land and water use is at the core of traditional state authority. Justice Thomas's concurrence says states have primary sovereignty over their waters. And then the petitioner's brief is agreeing with that. So this is the Sackett folks saying, states are fully competent to protect their waters. And it cites a couple of other briefs saying, a lot of states have wetland protections and they're going to some states will heavily regulate, even if the Sacketts win their court case. So this is not to say that I think Sackett is a good case, but I'm saying we have to figure out what to do next at the state level after Sackett. And the nice thing here is that contrary to kind of the complicated looping, finding a connection through the Commerce Clause that you have to see under the Clean Water Act, states have authority to regulate waters, including wetlands, if they choose to do so. That's another matter, but it's a lot clearer if we want to take some action at the state level, we can see kind of how we want to go from there. So what does Sackett mean for the states? So as we saw already, those non-adjacent wetlands, those are removed from federal jurisdiction. But what that means depends on what laws your state has in place. So some states immediately lost protection for those wetlands. So there's a number of states that I'll get into in the next slide that rely on federal protections to protect their wetlands. So if you don't have state level protections, those wetlands after the Sackett decision lost protection. There are other states that have state level protections, and a lot of them, the way that they work is they set kind of a lower floor for state protections that's underneath the federal jurisdiction. And then they kind of float up to that line where the federal government takes jurisdiction. After the Sackett case, there's now a gap where federal jurisdiction has suddenly gotten more difficult to prove. And in some states, that gap exists between state law and federal law. And then in other states, their protections are now responsible for protecting more wetlands than they were before because you have to kind of fit it into this box. So that's an additional burden for some of these states that they weren't necessarily anticipating when they passed their wetland law because federal jurisdiction has now gotten harder to prove. But it's also a potential opportunity for regulatory certainty in some of these states if you can pass a state program, because as Haley and Chris pointed out, WOTUS is going to continue to change. Those federal jurisdiction is going to continue to be litigated and change across the country. And if you can get a state program in place and design it well enough that it can kind of float up to that federal line and coordinate with the core where those jurisdictions meet, you can provide some certainty underneath that at least these wetlands are going to have some protections at the state level, no matter what happens up at that upper bound of kind of state authority. So this map shows state protection of non-federal waters, and I got this from Environmental Law Institute. So this is just to show you kind of the context of where the states are in this scheme that I was just talking about. So the brown states are 23 states that rely on federal protection. So these are states where you didn't have wetland protections. The wetlands that are no longer under federal jurisdiction after Sackett are not protected, and there's no state protections to fill the gap. So that's 23 states. These kind of hash marked states, 7 states and the District of Columbia protect some non-federal waters. It varies really widely. That's a broad range of states, but they have some kind of protection in place that does go beyond what the federal protections are. And then these 20 states in green, these are states that protect most non-federal waters. Again, that looks different depending on what state you're in, but these are kind of 3 broad categories for state protections. So what we had to do after the Sackett decision, getting into like the nuts and bolts of what does it mean to work with the states. So I talked to our kind of policy folks, government relations, and our staff in the field to look at that map and say, all right, well, what does that mean? Where might things change after the Sackett decision? So kind of sorting states into 4 categories, and then also essentially 4 categories, 2 categories, there's not really any action that needs to be taken, and then 2 where action might need to be taken at the state level in the state house, depending on what we're seeing. So the top and the biggest category is 20 states without the political conditions to expand protections, at least right now. So these are all brown states. These are states that don't have state level protections, and it doesn't seem like the conditions exist right now to expand those protections after Sackett. The next category, 16 states and DC. These are states that have existing protections, and they're not likely to be threatened after Sackett. Because there is a movement in some states, like Haley and Chris talked about in Louisiana, where some states are actually looking to roll back those protections. The state protections are more exposed after the Sackett decision. And that's the next category is kind of these 9 states that have state level protections, but those protections could be challenged based on the political conditions that we see in the state. So that might be chatter in the state house, bills that have been introduced, the makeup of the parties and the governorship. So just sorting them into, okay, these are states where we might have to take proactive action to maintain just the protections that they have. And then the smallest category, unfortunately, the smallest category is 5 states that have the opportunity to expand their protections. So these states have no protections or some protections, and there might be conditions to expand those protections at the state level. So I'll talk about 2 states on the Mississippi River that we worked directly with. So Illinois is the first one. Illinois was an opportunity state. They have some existing state protections, but they're really patchy. They have a law that requires the state to mitigate impacts to wetlands, but it's only the state and state agencies. It does not affect private parties. And then they also have some really good county level programs under their stormwater authority that require wetland mitigation. But that is, I think it's only 6 counties in Illinois, and it's just the counties around, in and around Chicago. So most of the state private impacts to wetlands are not covered. So after the Sackett decision was issued, we got together with a coalition of other environmental groups and talked about, what we wanted to do, what we thought we could get done, reached out to the General Assembly to find a sponsor. And it quickly became apparent that what was politically viable potentially in Illinois was gap filling legislation. So that's legislation that would protect just those wetlands that lost protections under the Sackett decision. And that is a nightmare to try to draft, because any wetland or any stream or anything that is potentially included under this bill that wasn't included before Sackett is another opening for someone to kind of challenge it. So that's a lesson learned from this, is I wouldn't do that. And we actually were able to kind of move back from that. When you have legislators asking you to put the significant nexus test into a bill, you don't want to do that. And we said, no, thank you. We're going to come up with a different way to do this. Another challenge was needing to incorporate existing state and county programs. So that state law that I talked about, as well as those kind of county level mitigation programs that are operating actually really well and even above the threshold of what this Wetland Protection Act would require. So you have to make sure that you incorporate them in a way that allows them to continue to do that. Illinois has unique state political dynamics, is how I would put it. One of which is that Illinois has kind of perpetual fiscal challenges. So once our wetland bill is introduced, all of a sudden, the funding that it would require, whatever funding it would require for the state agency to implement or kind of get staff up to speed, is going up against transportation, affordable housing, climate change, like any other priority that you have in the state of Illinois. They're all competing together. So wetlands, unfortunately, are not as high at the top of the list for some folks. So that's a challenge in trying to pass the Illinois Wetland Protection Act. State agency engagement is also tricky, partly because of that financial incentive. It would require some sort of investment and additional staff from the state agency. So you have to make sure that they are comfortable with the new authority that they would be taking on. They're comfortable with the rulemaking that they're going to have to do. They are comfortable with the timeline. So you really have to go hand in hand with the state agency that's going to be implementing this to make sure that they are comfortable with the authority you're giving them and kind of the the wetland protections that we want to put in place. And that has been a challenge as we move forward with making sure that they're on the same page as we are. So the bill is still pending in Illinois. We are continuing to work with the legislature and work with other interested parties to kind of sort out where we go from here, where some parts of the bill could be amended to bring other interested parties on board, and where they're kind of deal breaker, and essentially also trying to make sure that it stays in the news, because unfortunately we are several years now past Sackett. So the responding to Sackett immediacy has kind of receded into the background, which may or may not be, which is a challenge. There may be an opportunity for us to kind of clean up some of the gap filling parts of the bill now that we've gotten a little further away from it, and we can bill it as less of a direct response to Sackett. But so Illinois is an opportunity state. I don't want to make it sound like it's not, but there are difficulties in a state that looks like, you know, it should be easier to pass a new wetland response after Sackett. Now I'm going to talk about Tennessee, which is another state that we worked pretty heavily in. Tennessee is a challenge state. Tennessee is a state that has fairly comprehensive wetland protections at the state level, but after Sackett, they were facing total repeal of protections. So there is a legislator in the Tennessee legislature who is also a real estate developer and has had to do a lot of wetland mitigation in the past, and he does not like that. So he introduced a bill after Sackett that said, okay, let's just get rid of the state level protections. We don't need these. We need to align our standards with the federal standards. We were able to successfully work with an environmental coalition to get that tabled and kind of kicked to a study committee over the summer for the state agency to look at like what potential changes that could be made. There were some kind of challenging enforcement actions that were taken by the agency and some things that could be clarified. So they did that research over the summer with the legislators and others interested parties, came back, and TDEC, their environmental protection agency, kind of issued their recommendations and said, this is what we think we could do to clean up our state statutes. And it also would remove some protections. There was kind of a raising of the threshold of wetlands that would be protected at the state level. So some loss in protections was baked into that TDEC recommendation. We get to the legislative session this next year. That same legislator says, well, I like those recommendations. That's not far enough. Let's just repeal them all. So he's back on the repeal all the wetland protections. And we had to decide what to do. We didn't think that same environmental coalition could again kill that bill entirely to eliminate the repeal of protections, especially because TDEC had issued its kind of recommendations saying that they were okay with reducing some of these wetland standards. So we worked with kind of a different coalition of groups, some hunting and fishing sportsmen's groups, to talk to the majority party and get them comfortable with kind of the TDEC recommendations. So some loss in protections baked in, but maintaining a lot of the protections and trying to kind of head off this total repeal. We were successful. That bill was passed, signed, and became effective. Little bit of a bittersweet victory because there was a loss of wetland protections in the state of Tennessee, but we have to count it as kind of a win in these times because we were able to head off the total repeal of protections, at least for now. And then finally, I know our next speaker is going to talk about Iowa, so I'm just going to put Iowa in context with what I have just laid up here. Iowa is one of the brown states that relies on federal protections. I didn't get into this with any of the other states. A lot of states have this. Some states have stringency limitations that limit how strict your state level requirements can be as compared to the federal government. Iowa is one of those states, so that is a challenge when you are trying to pass wetland protections that are more strict than the federal government's protections. And then there's also just some questions around the impact of Sackett in Illinois and the prevalence of agriculture. So with that, I will finish, and Larry is up next.
Tony, Haley, and Chris, it's a pleasure to be here today. It's wonderful, to see the kind of the glue across the presenters here, talking about Driftless to the Delta. Although the IHR program located here at the University of Iowa, I'll focus most of my comments today on Iowa relevant work that we're doing. We're a group that works around the world and across the country. We had recently did the hydraulic design for the Thames Tideway Tunnel in London, the stormwater system in Abu Dhabi, working right now in New York City on a stormwater system there. Recently completed with Troy Lyons studies on Ellicott City, where they had 2,000-year floods in an 18-month period with loss of life. So we're really a national and international resource. But the focus of my talk today is really on the programs that we've implemented here in Iowa. And in the 105-year history of the Institute, not until 2008, when the floods of eastern Iowa tore apart, so many of our communities, was our work so relevant in our state. Before that, about 99.9% of our work was all done outside of the state of Iowa. And under the direct leadership of then State Senator Rob Hogue, the Iowa Flood Center was formed. And, great for Rob to be here with us. And Rob and I chatted not that long ago, and we were talking about the Flood Center now in its 17th year. And I think, if I can quote you correctly, it exceeded your wildest imaginations.
Yes, that's accurate.
And I think maybe, well, I'll take that as a compliment. It's fantastic that the state of Iowa stepped forward in creating the Iowa Flood Center. It remains the only academic research program focused on flood science in the nation. Because of the IHR program that does both basic fundamental research as well as a applied engineering work, we were able to deliver on the promises that we made to the state legislature. And I think we've done that remarkably well. We were formed in the 2009 legislative session. For this past year and for the next year, our state budget is $1.5 million. I put this up here just for context. In the 17-year history of the Flood Center, we're today funded at $100,000 less than when we started 17 years ago. We had received an increase in funding when Governor Branstad rejoined the governor's office in 2012. We were moved from a one-time state appropriations budget into the governor's budget, remained there until 2017 when the legislature attempted to zero out the Flood Center because of concerns about the work that we were doing in the IHR program related to water quality, and we have been basically flat since then. We work across the entire hydrologic spectrum. As floods occur and as climate scientists have talked about for decades now, the climate in Iowa, which is changing. We're going to see episodic, long period, decadal type droughts that get broken by very intense torrential rainfall. And I think we saw that in 2012 and 13 up in Northwest Iowa. We saw that again in 2024. You might recall we were in a 3-year drought, a devastating drought across our state, about $250 million in crop losses because of that extended drought. That was ended by torrential rainfall. And this is the cumulative rainfall. This is information that comes off of our Iowa Flood Information System. We saw about 20 inches of rain in a 10-day period up in Northwest Iowa. A few rainstorms came through, they saturated the soils. We had fully saturated soil conditions. And then we had a storm event that came through that part of the state on a Friday and Saturday night that left Spencer, Rock Valley, Rock Rapids, Cherokee. This is Spencer with historic floods. 80% of the structures in Spencer have been impacted. Many of them destroyed. Over 100 households where the home was swept off of the basement or had the basements collapse. And we've been working, very carefully with them. Flash flooding, very different than the long-range flooding that we experienced in 2008, occurs across our states. We think about our long rivers, our largest rivers, the Des Moines, the Raccoon, the Iowa, the Cedar, the Missouri and Mississippi, both of our border rivers, as being kind of long wave flooding. Some interest right now in what had happened in last summer in June is to think a little bit more about these mesoscale convective rainfall events. The type of storms that happen where we get this repetitively narrow banded but intense rainfall. If we do a count of those across the nation, you see the count map here. Iowa's at the bullseye. So let's say Iowa and the northern couple tier counties of Missouri. This is the type of storm event that we saw in 2008. Narrowly banded intense rainfall that followed the hydrograph of those flood waves down the Iowa, Cedar, and Turkey and the Wapsie. We saw that again in 2016. Another flood was evolving during the 2016 period that was putting Cedar Rapids at risk again before their flood protection was finished. And we absolutely saw that in 2024. And so this is just a little signal to the future. What we're seeing is certainly evolving, and it's evolving in a more intense way. We do a lot to protect Iowa. Again, I think we are very, very proud of what was formed here in the state of Iowa. We've been replicated. You can try, again, the greatest, I think, compliment is for other states to try to replicate what we're doing. Missouri has established the Missouri Hydrology Information Center. We just learned this year that Minnesota has gone forward with some legislative action to create a Minnesota Flood Center. The Louisiana Watershed Initiative was formed after our Iowa Watershed Approach Project. Help Texas and North Carolina and many others. But when you see the map here of the monitoring that we've done, the U.S. Geological Survey is the nation's gold standard for stream flow monitoring. They have about 140 gauges in the state of Iowa. We've added to that 140 about 270. So almost tripling the number of monitoring locations in Iowa. You see them here. In our information systems, we integrate all of that federal data along with the flood center data. And we use it as equal, right? The flood center information is just as important as our federal response data. The federal data oftentimes is focused mostly on our larger rivers, upstream from our largest communities. But at the time of 2008, we recognized that we had hundreds of small communities in Iowa that live along streams that had no information. So they were on ungauged streams. And so we've been able to put these sensors out, deploy them, provide that kind of information to them. It's a unique system. We have some out in South Dakota. We're in discussions with North Dakota and putting some out there. Other states, again, have tried to emulate this. New York has a series of sensors out that are similar to ours. So we're excited about that as well. The lower right-hand panel, that's a local hydrometeorological station. Hydro station that we're deploying in the state. 99 counties in Iowa with very little soil moisture information. So we'd like to have one of these stations in each of 99 counties measuring soil moisture, soil temperature, 2 inches, 4 inches, 8 inches, and 20 inches of depth to shallow groundwater. We have 2 impact disdrometers that are scientific grade rain gauges that every droplet that hits the surface of a drum creates a vibration. We calibrate that to rainfall intensity. We have wind speed and direction there as well. So we're deploying that across the state of Iowa. Flood mapping, the example of our flood mapping system. This, of course, is the Cedar River and Cedar Rapids. Has a USGS gauge that you can go to and you can understand what the gauge elevation is. But in 2008, as the Weather Service first forecasted a 20-foot crest, the levee height was 22 feet, and they raised it to 22 and 24 and 28 and 32. That escalation happened over a Monday through Friday period. The stair stepping is because of those mesoscale convective rainfall events that kept coming through, putting more water on that flood wave coming downstream. With a very simple online Google Maps based system here, you can slide the slider bar, pointer to work, from the left or right. We can put it at the stage level forecasted by the Weather Service and shows the extent of water. So what is the extent of flooding? Here we show a damage estimate tool that we have, but you can also select the little box above it where it says water depth, and then click anywhere within that blue inundated area and know what the depth of water is at your house or your business or your school. And so this is a kind of information that doesn't exist anywhere in the country. You're in Iowa. We're very proud of that. We also, because of the Iowa Flood Center, and the Iowa Nutrient Research Center, and the Iowa Geological Survey, all in part or all held within the IHR program. In 2014, we were asked by the governor's office in the state of Iowa to lead the effort towards submitting a proposal to the U.S. Department of Housing and Urban Development into what they called the National Disaster Resilience Competition. The big title, $1 billion, $500 million from HUD, $500 million from the Rockefeller Foundation were put into a fund to do a program. We were awarded $96.9 million in the state of Iowa, so about 10% of the overall fund. We built 700 different conservation practices out on private lands. We built $40 million in gray infrastructure. We provided cost share, and we really developed what has become a best-in-class watershed program for the nation. We're doing these practices, and as I said, in the watershed project, we will run out of money before we run out of farmer interest. And without a doubt, we had many people on our list that still wanted practices. The challenge is we're competing against the industrialization and intensification of agriculture. In the Middle Cedar, where we built 84 different practices and spent $7 or $8 million, and this is one of the watersheds that were built in the Middle Cedar. In the same period of time that we did that implementation, 8,400 miles of additional subsurface agricultural drainage were installed just in that watershed. of the 50-some Huck 8 watersheds in our state. So that's a challenge that comes with an environmental cost and a sacrifice. We've heard an awful lot about water quality in Iowa here in this last year with high nitrate levels throughout our state, especially in central Iowa, the impact on the Des Moines Waterworks. We run the nation's best in class, again, real-time water quality monitoring network. This has been funded through the Iowa Nutrient Research Center. Faculty at Iowa State focus on in-field and edge-of-field best management practices to reduce agricultural nutrient pollution. Our role has been to run this water quality monitoring network. And in this last year, we had 53 sensors out. We've had that network as high as 70 to go along with 12 USGS sensors that are sort of statewide distributed. And the USDA has another 8 sensors that are located on some research projects that they have. In 2023, the Iowa legislature chose to defund the water quality monitoring network. In a year later, that was fully implemented. We were able to get some continuation funding from the Walton Family Foundation to keep the network up and running through next summer, at which time, our network will get pulled back out. Thankfully, just last week, we heard that Hull County passed a resolution to commit $200,000 for FY27 to help to fund our network. We just had conversations this week with Lynn County, and we have a meeting upcoming with Johnson County. We've heard some interest in Dubuque County, heard some interest from Winnebago County. So we've got other counties that are really interested in stepping forward. This is an important statewide network for us. Now, are we making progress in water quality? I think that is, left to perhaps the beholder. But ag pollution in Des Moines continues to keep people up at night. EPA says river nitrate threatens Cedar Rapids as well. And then, of course, and very disappointingly this spring with the new federal administration, under the Biden administration, there were hundreds of millions of dollars in farm conservation program projects that were being built across the nation. Trump spending freeze put a stop to some of that and reverse some of that. We face a water quality crisis, Cedar Rapids as well, so we can talk about that more. Vision for the future. I think that what we've shown in Iowa is that we can make our environmental projects work very well with agriculture. We've got to be able to have open scientific discussions about how best to do that. We need to start with a water plan. We heard about planning both from Chris and Haley and Cody. We haven't updated our water plan in the state for 30 years. Why is that? I think it's because there are parties that are afraid to come to the table to have that conversation. We got to figure out what the carrying capacity and what the right amount of industrialization of agriculture is right for our state. In central Iowa, in the Raccoon and Des Moines rivers, 80% land down, 80% by area in those watersheds is row crop agriculture. Have we surpassed some tipping points that make our natural systems filtering of some of those ag pollutants possible? And so we had to start thinking about that. And so with that, I think we're going to open it up for questions and for each or any of the panelists.
Perfect.
Thank you. Thanks, Larry and Haley, Chris. I think we're gonna go around and pick up questions from the audience. I don't see Blake right up there. There's Blake. So if you have, I think you have note cards and pens in your rows. If you want to jot down some questions, we have a bit of time to take some questions from the audience. So I'm not sure if you can need your mics or not, but let's just see what happens. So thank you so much. You've done a wonderful job of starting here and bringing it down. So I really appreciate that. I've just got a couple of questions what are the impacts beyond wetlands that you've seen in any of your work in the basin or beyond? So we heard a lot about how it's affected in the states and boundaries and so on, but what about beyond wetlands? What are you seeing there?
I think one key area that's overlooked a lot when we talk about the protection of wetlands is on the federal flood insurance program. I know that's something that's very important in Louisiana, and I know it's important in Iowa as well. And a lot of states and the flood insurance program is federally funded, but it is mostly managed at the local level. And as you've seen, there's not a ton of widespread wetlands protections beyond the Federal Clean Water Act. And with this change in jurisdiction, that means a lot less wetlands will have federal oversight, and that means there will not be the same sort of mitigation, and those mitigation requirements exist under the Federal Clean Water Act to retain the same ecosystem services that existed before the development. And that's not always perfect, but it is getting to the idea that if you fill in a wetland and develop, that floodwater will just go somewhere else. And so now that this jurisdiction has changed, we're going to see a lot more development at the local level, and local governments don't have a handle on what that development looks like. And I think that it's going to be changing the flood risk in areas that have, sort of had an idea of their floodplain risk and the mapping of that. So lots of other programs are implicated, not just Clean Water Act.
And maybe just an expansion on that, following the 2008 floods, we remapped the entire state of Iowa and updated all the floodplain maps for the state. And when we did so, we didn't map out just the 100-year and the 500-year extents of floods, but we did the 2-year, the 5-year, the 10-year, the 25, the 50, the 100, the 200, and the 500-year extents. And so we could really see the spectrum of risk across the floodplains. And following that, a number of our communities and urban areas chose to adopt the 500-year as the regulatory floodplain. Again, putting more protection in terms of future development. And so I think that was a really important thing for us from a, flood recovery response, that we don't have people building down in those floodplains next to the river. The other piece of that information, though, allowed us to intersect those floodplains with all sorts of things: schools, hospitals, critical infrastructure, and ag land. And we saw that we have about 400,000 acres of row crop land in the 2-year floodplain. And so oftentimes I get the question, gosh, Larry, why does it flood more than once in 100 years in the 100-year floodplain? And we can answer that later. But you can think of the same thing about the 2-year floodplains. We have 400,000 acres of cropland that could be taken out of production and put into conservation. Again, having less of an impact on water quality, doing more in terms of flood resilience.
I'm going to merge a couple we have great questions. Thank you, everyone. These are wonderful. So, Cody in Tennessee specifically, but maybe any of you, you mentioned the coalition of folks interested in water quality regulation. Who are these constituencies? And I'm going to tack on to that. Have you seen any, or do you predict any unexpected allies in the space who might be brought together to work on these issues in the states that maybe we haven't seen before? Any of you can.
Yeah, I mean, I would say in Tennessee first, it was a lot of the environmental groups that you would expect. It's TNC, it's the environmental councils, it's Tennessee Wildlife Federation. Sometimes there were hunting and fishing groups involved in that coalition, but really the initial coalition was more, I would say, left leaning. And then the second coalition that was smaller was deliberately more of a moderate coalition to appeal to the conservative Tennessee legislature. So you kind of have to shape your coalition as you find them, as you find the legislature. But as to the other part of your question, like who are some kind of unexpected allies? We have had some good conversations with folks in kind of the insurance industry is one where, like Haley said, the water is going to go somewhere, the flood water is going to go somewhere, and we have to account for that. We've also have had some good conversations with affordable housing, housing developers, because that has been a real thorn in the side of wetland regulation, is that saying that wetlands are the enemy of affordable housing and saying, there's a way to square this circle. There are some incentives that have been floated out there, for example, allowing for denser developments if you can avoid impacts to wetlands. So trying to kind of blunt that tool of affordable housing as the kind of the bane of wetlands.
Okay, Larry, you mentioned this. How would a state begin making water? You talked about that too.
Well, water plans exist all across, the country, and of course, upstates up and down the Mississippi River. Iowa has a water plan. It just hasn't been updated since the 1990s. It was originally, I think, crafted in 1978 and hasn't been updated since 1990. So we need the political will to do it. We need leadership from the governor's office. We need to get the right people at the table that represent all the interests in water-related issues, and hopefully we would lead that effort with science.
And yeah, it's like with any of this stuff, you can have the plan you can have it even made, or you can have the law on the books calling for a plan, which is, where we're just getting to in Louisiana. But actually enforcing and executing the plan, right, is where it's usually the hardest step. And so you need that sort of organization and energy. Honestly, I've seen a lot of it this week here. And I was in Chile a couple of weeks ago at a UN Regional Dialogues on Water conference, and they were asking me about legal frameworks for water management. And I was like, you guys are already doing it. Everything I've heard, you have these frameworks already in place. It's just about someone who's able to use that sort of political juice to actually see it through. And it's true here in the States as well.
We just have time for a couple more. We have another class coming in here in about 10 minutes. So I'm gonna kind of start out smaller. So maybe some of the folks here or online are thinking, what can I do? And so if you want to start thinking about what people individually can do, I have a question. If state and local protection of non-modus water resources and regulation of development is to step into the gap post Sackett, do you have any county level regulatory regimes that can be considered success stories? Or do you have any suggestions for avoiding state preemption?
Yeah, I mean, zoning is really important. We have one example in Louisiana in one of the parishes that's upriver from us, where you would, it's a small government kind of culture there, but they flooded so much and so badly so many times that they've started instituting floodplain zoning. And it's the sort of place where just common sense eventually prevails. And so yeah, those sorts of local efforts are extremely important.
Yeah, I'll just say too, another plug for the counties in county programs in Illinois. They actually regulate wetlands under their stormwater authority, but they have a really comprehensive programs that do a great job. And we actually have had to do a lot of work to make sure that we don't interfere with those programs, because they would, as they exist right now, they go much further than even the legislation that's been introduced in Illinois. So they're a real success story there.
Yeah, my interest is less in wetlands specifically, but thinking a little bit more just about kind of the resiliency of our systems. I've been around this business and doing this for a long enough period of time that, I look back over a 35-year career, there's no question in my mind that our water, by way of flooding and water quality, are getting worse. And if we want this state to be a welcoming and livable state in the next 25 or 35 years, we need to start, understanding these systems. And so my encouragement at the local and county level is to get people active, get them involved, get them understanding these changes. These things can be complicated, but, to think about conservation and think about these things with a much longer view than the 1 week or 1 year or one election cycle.
We have time for one more question. I'm gonna force each of you to answer. I'll give you a little minute to think about it. So certainly this new sort of piecemeal framework created by state gap filling and uncertainty is not likely to provide protection to our waterways. How do you remain hopeful in a future that includes clean rivers, lakes, and waterways?
I'll start to give our out-of-state guests some time.
Like 7 days about giving, so
Well, and I think for us, we know what works. We've done this in Iowa. I think as we shared with our friends from Tulane, this Iowa watershed approach was a practice where we established local watershed management authorities. We had local people working on watershed plans. They determined what they wanted to do for goal setting in their watershed for stormwater reduction and water quality improvements. They had watershed coordinators that woke up every day to make the watershed a better place. We provided funding at 90% cost share to get practices built. So we know what the model is. What they need is real, renewable, and reliable funding to be able to implement these practices. The state of Iowa, by a vote, was 63% in favor, passed the Iowa Water and Land Legacy, or the Natural Resources Trust Fund, so that the next time the sales tax was increased, the first 3/8 of a cent would go to fund the trust. For over 10 years now, that hasn't been funded. And whether it comes from I-Will or other appropriations, we need significant resources. An estimate is that we need about $10 billion into our watersheds, putting conservation back on the land. And at $200 million a year in 50 years, we could change the way water and nutrients come off our land. And if you think back over the last 50 years when we were losing soil at an accelerated rate, the Soil Conservation Commission came in and put grassed waterways in and worked with landowners to change the way soil came off our land. We changed that paradigm in 50 years. We could do the same with water and nutrients.
Yeah, I'll just say really quickly, I think there's a growing awareness of water quality challenges across the country. I mean, TNC's been pulling on water issues for decades and consistently concerned about drinking water is the highest polling issue. Everyone's concerned about their drinking water. And I think you're seeing more algal blooms, more nitrate challenges. And then we are also kind of in tandem, there are new tools that are developed that you can actually see. You can better kind of map and understand where these things are coming from. So I do think that kind of that increased awareness with the increased ability to show, like I was telling folks earlier, that the algae bloom in Lake Erie was not caused by Canada geese pooping next to the river. We know where it comes from. So being able to kind of match those together kind of gives me hope.
I think one thing seeing this kind of work done in Louisiana, which needs so much help in terms of water quality, wetlands, coastal issues, you might not be seeing it at the highest level of agency leadership right now, but over the last couple of years working in the space with Army Corps, EPA, industry stakeholders, navigation interests, and community groups, is that there's definitely a movement that I'm seeing within all of these different groups towards acknowledging the shared issues that we have around water and climate change, and that we can't be continuing business as usual approaches and watching the Army Corps consider different ways to manage sediment and river openings and closures in coastal Louisiana, and hearing the navigation industry discussing addressing climate change in the event of low river events and how that is something that ties us all together. It's maybe not the rallying cry in this exact moment, but it is something that, I mean, living in the, whether you're in Iowa and your reality is this nitrate problem, or whether you're in Louisiana and you're facing hurricanes and coastal collapse, it is something that we can't ignore it, and water is a very important tying theme between all of these different stakeholders and communities.
So you know the story about the guy who goes to his doctor and he says, I'm crying all the time. I barely even want to get out of bed in the morning. I'm just so sad. The doctor says, what you need to do, the circus is in town. You need to go. You need to see this clown, Pagliacci. He's incredible. He'll make you feel so much better about life. And the guy says, but doctor, I am Pagliacci. I always think of that when I get this question, and I want my answer to be, it's the students that I get to work with. Because I don't want to put it all on them, especially if they're already feeling put upon. But like the difference I feel like for me, as opposed to like some of our colleagues who work at various law firms or NGOs, is that we get to work with these students every day and get to see the energy and the vitality and the fresh ideas that they're bringing to this. And so I like, that's, you know, what gets us going every day. But I will also say what's also wonderful to see is the people who've been in this, working on these issues, this fight for decades, and their willingness to mentor and to pair with those students is something. And we have people who have practiced law for decades and then in retirement come to us and say, hey, can I hang out with you guys and like work with these students? And that's exactly what we're looking for. Yeah.
Thank you so much, guys. That was. You got 5 minutes. It's like I was always
Like talking about those like shit.
But from those
Wake up in the morning, you change anything, so ideas, there's other ways maybe.
It's truly. Oh my gosh.
Yeah. I put it in touch with you. I sent you an email on that.